I swear by Almighty God that the evidence I shall give to this honorable legislative assembly shall be the truth, the whole truth, and nothing but the truth.
Good afternoon, Mistress Rosie Whitaker Miles, and thank you for coming early at short notice. We appreciate it because we know that you're busy, and so we appreciate you taking the time. What we want to talk to you about is the fighting corruption in the Cayman Islands, which was a report done by the Auditor General's office in November 2018. And what we want to talk to you about is the standards in public life commissions. And as chairman of the board, we note that you have dutifully filed your reports, and they're always very interesting to read, but your constant complaint is the lack of the legislation to give you the authority to do many of the things that you wish to do. So can you give us any update on where the legislation is? Or
Good afternoon, Mr. Chair and members. Thank you very much for affording me the opportunity to appear before you. I, too, read with interest, and I'm really, and I speak on behalf of the Commission when I say that we are really pleased and thankful for the Auditor General that she highlighted in her report the need, she referred to it in one instance as an urgent need for this law, the Standards in Public Life law, which was passed in 2014 and amended in 2016 to come into effect. We have, as you've quite correctly indicated, we have, as a commission, sent a number of letters. We have gone to the extent, as a commission, of drafting information that we thought should be included in the regulations for the law. Because obviously, if we have a law, we will need some regulations as to the operation of the law. And we have followed up on many occasions. The last we heard was at a meeting with His Excellency the Governor late last year. We were told that His Excellency would be bringing to the attention of the Honorable Premier the concerns of the Commission, and to request that something be done very quickly to have this long delayed matter resolved. So that's as much as I can tell you about where we are right now. We have since then not received any communication from anyone as to whether any communication has taken place, but the Commission is aware that they're based on other persons who appeared before this committee to speak to the report of the Auditor General that there may well be some further amendments, but this is just based on what we've read in the newspaper. We don't have any more information on it.
the information that we've been getting, I can tell you that in my other role as leader of the opposition, I myself have requested the governor to make haste to get this legislation into effect, partly, and we will be making a very strong recommendation in this report that we table, hopefully, during the meeting that starts on the 4th of April, that the legislation be brought into effect ASAP. As we understand it, it appears that certain persons who sit on boards are objecting to some of the requirements that the law will place on them. But I find that, quite frankly, a bit disappointing, because the whole point of the legislation, and if you are on a board for reasons other than altruistic reasons, then I think you shouldn't be on the board. I have not been. I know that the time has passed where the government can give the 21 days notice for the next meeting of the Legislative Assembly, and unfortunately, the standards in public life does not seem to be on that for that meeting. So, and the last time we met was some 4 months ago. So if we're looking then another 4 to 6 months, that is reasons to be concerned. How difficult is it for you to do your job without the supporting legislation?
Thank you, Mr. Chairman. It's very difficult for the Commission to operate in the way that it is established by the highest law for land, the Cayman Islands Constitution, Section 117, to operate the way it should be operating. One of the major responsibilities for the Commission once the law comes into effect will be the Register of Interests, establishing and maintaining that Register of Interests. And obviously, if the law is not in effect, we don't have the power to deal with that aspect of our responsibility. So to answer your question, that being one of the primary responsibilities of the Commission, we are not being effective. With respect to other aspects of the functions of the Commission, we have boldly stepped into certain arenas and requested information and requested inquiries, and we have met with no objection whatsoever. Whenever we asked for information or we asked for follow-up, we got clarification. So we realized, though, that someone could respond and say, well, you know, you don't have a law in effect, so we're just not going to respond. But that has not been the case, so we're grateful for that.
Have you found this huge resistance to the implementation of this law? Because I cannot say with any certainty that I have found a lot of opposition. The cry that I hear from the general public that I represent is, when is this law coming into effect? So much so that I can tell you that they're bringing one of the pieces of legislation that they're bringing in the June session has a similar clause to it, and I will be filing an amendment to put a time limit on that clause, that the law, well, even though it'll be brought in by cabinet, I intend to try and amend that section to say it must be done within 90 days or 180 days, or put some figure there, because when it's left like this, 10 years from now, the political arm of government can get the credit of passing legislation in all the international bodies and locally, but have no fear of it being implemented.
With respect, Mr. Chair, to the question as to whether or not the Commission has encountered any resistance from board members, I can't say that we have. There was a training session that was held last October at, I believe it was at the Marriott, where the Secretariat very kindly arranged for board members and others to participate in a training which would familiarize them to the various laws that they need to be complying with, the standards in public life law being one. The Auditor General, I believe, was at that training session, as well as was the Ombudsman and the chair for the Anti-Corruption Commission. There were one or two people who approached members of the Commission who indicated that they had very strong resistance to the law because of what they understood would be required of them when the law comes into effect. No one has come to me and expressed such sentiments, but I can tell you that having talked with the Honorable Premier, he has expressed to me, as he has in other places, that there's quite a lot of resistance from persons who are lay persons, who volunteer their time and their effort to serve on boards and committees, and who feel that they shouldn't have to be disclosing to the general public their interests and assets and income and liabilities. So no one has expressed any objection to me personally, but I've heard through others that there are some objections.
Through you, Mr. Chair, what areas of the civil service behavior code does the Commission have power over if the law was ever put in place?
Through you, Mr. Chair, the Commission's functions are to set and establish the highest standards of integrity in public life. So there is, that gives the Commission a very wide ambit as to who they will be responsible for and where they can be asking questions and getting additional information and pointing out things that the Commission thinks is not being done appropriately. So I think the Commission will have very broad powers once the law comes into effect.
Through you, Mr. Chair. What will happen, in your opinion, if a civil servant comes before the LA during budget or comes here before PAC and tries to misinform us or gives misinformation? What, in your opinion, will happen or should happen or will happen? Let's start and go with what will happen.
Well, I believe we had an example of that not so long ago, where there were allegations that some misrepresentations were made. The Commission did make some initial inquiry. It is something that we will continue to follow up, but there is already in place, even without the law being in place, there is already provision for these matters to be looked into. Having said that, however, if the Commission considers that those avenues having been explored, that there is something else that the Commission should be doing, then by all means, when we have the power to do so, we will be doing so. Or I would imagine any other commission would be doing so. And I must point out any other commission because for myself and at least one other member of the Commission, our term has already expired but was renewed for a few months until the end of this year.
Thank you, Mr. Chairman. Thank you, ma'am.
Thank you, Mr. Chairman. Through you, first of all, I certainly want to again add my voice to the welcome to the witness for appearing.
Thank you.
Thank you for being before us. If I could refer first directly to the Auditor General's report, paragraph 37, which is found on page 18, which speaks specifically to the Standards in Public Life Law. It starts out by saying in the opening paragraph, the Standards in Public Life Law 2014 does not yet have a commencement date, despite being passed by the Legislative Assembly 4 years ago. This is a major gap in the framework for combating corruption, and it weakens the intended impact of the framework. It goes on in the closing lines to say the fact that the law is not yet enforced may also affect public trust and lead to lack of integrity, transparency, and accountability. Now, Ms. Whitaker, the chairman in his second question asked you how your commission's role was being hindered by the fact that the law is not in effect. And whilst you stated that in respect to the Register of Interests, you were restricted, you also gave testimony that whenever your commission asks for information, they have yet to be denied. You also just stipulated moments ago that despite the absence of the Standards in Public Life Law, there are other laws and mechanisms that provide the support that would otherwise benefit the work of the Standards in Public Life Commission, namely the anti-fraud policy, which was implemented across government, I believe in 2017, 2018. So again, I ask the question, how precisely is the work of the Standards and Public Life Commission being hindered in the absence of this law?
Well, through you, Mr. Chairman, as I indicated earlier, one of the major functions of the Commission, one of the primary functions of the Commission, when it has the law in effect and it can do what it's supposed to be doing under the Constitution and under the law, will be dealing with the Register of Interests. Now, you're quite right in saying that that is one aspect of the law. However, that's a very important aspect of the law, I would say. And I say that because the Commission itself has had the experience of making an appointment, going through the process of making an appointment to inspect the Register of Interests, which, as you know, deals with the declarations or declarations that are being made by members of the Legislative Assembly and those who run for office and some ex officio members of government and, in some limited respect, the members of the press. Now, the Commission has on 2 occasions inspected registers. And on the last occasion that it did so, it identified certain areas that it was, more information was certainly needed and clarification was needed. Now, the Commission did so because we don't have a law, so we don't have the power to do certain things, but we did so in any event as persons who, if we had been challenged, we would say, well, it's a matter for the public. The public is entitled to inspect, and we have done so. And I'm sure I say on behalf of the Commission that we are not satisfied with the responses that we've received from the inquiries that we made. We still have outstanding information, and we are the Commission. We're not just members of the public who would have asked for this information. So the Register of Interest, we say, is very, very important. We don't believe that there is sufficient scrutiny and there is sufficient management of the register as exists, which is the whole reason why which is one of the reasons why the Register of Interests is prescribed under the Constitution. You're quite right in saying that whenever matters have arisen since we have been appointed, we have not met with any objection. But that doesn't mean that there are other areas that we could not be involved with and that people would not come to us with concerns about as a commission. So until we are fully functional, we don't know whether there are other people out there who would not have found us and made inquiries through us or made reports through us that we would investigate.
Mr. Chairman, thank you. Mr. Chairman, through you, with the greatest of respect to the witness, I don't believe this committee is satisfied with the answer that there are hypothetical circumstances upon which the Commission could act, but is somehow being hindered. The question was specifically, how are you being hindered? What examples can you give? Do you know for a fact that persons are failing to come forward because there is a lack of law? I'm just trying to understand how your autonomy, which is provided to you, again, as you quite rightly stated, by the Constitution, which is the highest law of the land, paragraph 117, section 9, subsections A through G. That Constitution does not stipulate that it requires a law to be enacted in order for you to fulfill your mandate. And again, whilst I appreciate that there could always be issues that could be addressed but haven't for one reason or the other, I'm wondering, are there specific circumstances whereby your commission's duties and obligations have been hindered, either by direction of the Constitution or otherwise, by the absence of the standards in public life law? Thank you, ma'am.
Through you, Mr. Chairman, I cannot say that I am aware, or I don't know that there's any record of any previous commission having been made aware, because you're aware that there was one commission before ours, been made aware of anything, any complaint that may have been made that would have been hindered by the absence or the lack of the enforcement of this law. That's my brief answer to your question. But having said that, obviously, if a law is in effect, and the law, well, if a law is anticipated by the highest law of the land, and the general public is made aware that that law is going to come into effect because there's provision for it within the Constitution, the general public then would have an expectation that, you know, the legislators and those responsible for bringing laws, especially laws that are passed into effect, because obviously they have a purpose. And until the law is in effect, we don't know how it will be used, how often it will be used, but I would hope that you would agree with me that there is a need for the law to be brought into effect, as with the many other voices that have called for the law to be brought into effect.
Mr. Chairman, through you, one final question. Whilst I agree with you that certainly any law passed by this Honourable House should in fact be anticipated to be implemented, I also like to note that as an elected member, we are elected by the people for the people. And in that vein, whilst I asked this question of the Honourable Deputy Governor on the 30th of January when he appeared before this committee, let me ask you, because there seems to be some degree of confusion, if not malignment, by certain members of the media as to what the significant objections are behind this delay of the implementation of the law. I wonder, can you state whether the objections you have received, heard, or otherwise know about relating to the delay in the implementation of this law, are those objections emanating from the public sector or members of private society who in this instance may specifically serve on boards?
Through you, Mr. Chairman, I can only repeat what I have been told and what I've said already. Nobody has come to me specifically and said, I object to this law, or because I don't want to file a declaration. No one has come to me with such a complaint. I have heard that there are persons in the private sector who serve on boards, and a member of my commission expressed to me at shortly after the training in October of last year that at least 2 persons, I believe she said, came to her and said, you know, this is going to be a problem. They would object. I've heard from others that there will be objection, or there is objection. I've heard from the Honorable Premier himself that persons who serve on boards have indicated that they have a problem. And they will object. And in fact, in one newspaper article, I'm sorry I didn't bring it with me, but there was some coverage where there was reference to a mass exodus of persons from boards if the law came into effect. Nobody has expressed that to me. And if I may, I think that the fear, the concern, if that really is one of the reasons for the delay for the law, can easily be answered by the law itself. Because whereas Section 11 of the law requires that declarations are to be filed. Section 12 makes it very clear that declarations by board members will only need to be filed, declarations of their interests and assets and income and liabilities will only need to be filed where there is a possible or perceived conflict of interest. So if the capacity they're functioning in as a board member, if there is no interest in their own assets and income and liabilities, and that of their immediate family, which has been defined thus far as spouse and dependent, if there is nothing there, then there is the declaration will be a nil declaration until such time as something arises, and if something arises, then the declaration will need to be made, and the other steps that the law prescribes will be taken. For example, you're recusing yourself from the decision-making process and not returning.
Mr. Chairman, just have a comment. Certainly I agree with the witness, but certainly I think therein lies the problem. If members will not declare their interests, then how will the boards, the ministries, or otherwise be able to identify a potential conflict if they do not know there are ownership of properties or business interests, pecuniary interests, or otherwise? So to suggest it as a solution, which I think is a logical one, is lacking if we do not know in advance that there may be a possible conflict, if you follow. But I thank you very much for those answers, ma'am.
Mr. Chairman, the witness had quoted section 117, I think, of the Constitution that deals with Commission for Standards in Public Life. I just want to add one bit, that the Constitution itself is broken down into 9 parts. And section 8, in which the Commission for Standard in Public Life falls, is under the section that says institutions supporting democracy. So it is not just a matter of what the Constitution says. For us as agents of democracy, we need to recognize that the highest document in the land touched on the importance of having institutions to deal in terms of supporting democracy. And I have here with me the Standards in Public Life law that was passed by this House that has not gone into effect. And I'm going to ask the witness, there's a simple yes or no, as I go through the menu reading from the law, and just ask a simple question. It says, starting from in section 5 of the law, the functions of the Commission as prescribed in the Constitution are A, to assist in the setting of the high standards of integrity and competence in public life in order to ensure the prevention of corruption or conflicts of interest. And I'll ask the witness for the first one, and I'm going to go through each of these individually and ask, are you now able to do this with the law not being in effect? Are you able to do this, Madam Chairperson?
Sorry.
Yeah. Sorry, just okay. a yes or no. I mean, the law isn't in effect.
To assist, yes.
Okay.
I believe we're able to assist.
Okay.
However, in order to ensure the prevention of corruption or conflicts of interests, we obviously cannot do very much.
Okay, thank you. Second question, to monitor standards of ethical conduct in the Legislative Assembly, the Cabinet, and on the part of public authorities and public officers. Are you guys able to do, is your commission able to do that at this point?
To an extent, yes, I think we can. But we wouldn't have the full powers, and I can indicate at this stage, and I know you said yes or no.
Yep, that's fine.
But I can indicate at this stage that there is, we consider to be included in monitoring and standards of ethical conduct in the LA. We consider that the the ministerial code of conduct will play an important role in that. And as far as we're aware, we've made contributions to that code, but it's not finalized, is our position. So.
Section 5C reads, to supervise the operation of the Register of Interest and to investigate breaches of established standards.
We don't have, Mr. Chair, through you, we don't have that power at this time.
Okay. D, to review and establish procedures for awarding public contracts.
The answer is yes. However, and I should qualify that just by saying that the previous commission's chair played a very important role in moving forward a law the law that we now have to deal with public contracts. However, we have a limited role to play. We were asked to contribute to the law when it was in draft form and the regulations, and the commission did so.
Okay, 5E, to review and establish procedures for appointing members to public authorities and the terms of their appointment.
Mr. Chair, through you, to the extent that we can request information and follow up on information, yes, we can do that at this time. Whether or not we will get the response that we would want, I don't know, but we certainly can review and establish, review and establish procedures for appointing members.
Okay. On F5S, to recommend codes of conduct to prevent any minister, public authority, or public officer employing their power for any personal benefit or advantage, and to recommend legislation to provide appropriate sanctions.
I would say that we certainly have, the commission has certainly conducted itself as if it has the authority to do so, because we have certainly provided some feedback and input on the draft code, as I indicated, and I thought would come under the ethical standards as well. However, that's all we can do. We haven't been able to move anything forward because we understand that that is with the Cabinet Office and with others. So we've sent in our recommendations.
Sure. Just looking at Section 5.2 of the law, that still hasn't, and that was passed but hasn't gone into effect. It says, in the exercise of its powers and performance of its functions under this law and the Constitution, the Commission, A, shall not be subject to the direction or control of any other person or authority. B, may, in cases where it considers it appropriate to do so, make use of any external advisors. And C, shall have the same powers as those of the Grand Court to summon witnesses, require the production of reports, documents, other relevant information, and D, may do all such things as are necessary or expedient for the purpose of carrying out its functions. The question after reading Section 5 through you, Mr. Chairman, to the witness is, without this law being in effect, are you able to basically do all the stuff listed in Section 5.2 as that would be required for you to basically perform your role as part of a commission that is supposed to, as per the Constitution, be part of institutions supporting democracy?
A brief answer is no. And one of the most glaring provisions in that section is the power to summon witnesses and require production of reports and documents and information. We clearly don't have that power as yet. We won't until a law comes into effect.
If I could get back to number 2. For instance, when you said you inspected the register of interest for members of the Legislative Assembly, if, for instance, you found instances where members' register of interest may not be up to date, You'd have no way of knowing whether they're complete or not, but not up to date. And if you was to discover that the Legislative Assembly body that is established under the Register of Interest law to monitor and to ensure compliance with that legislation has not met for years or has not filed a report to Parliament on the functions of that committee, without the standards in public health law, you now have no authority to require that that be done. Is that so?
That is my understanding, Mr. Chair. As a commission, right, we wouldn't have any power to do so. I know, however, though, that under the Register of Interest law, there are certain provisions for complaints to be made. So I would imagine that, as with any member of the public, we would have the right to make a complaint if we're not responded to.
But if a proper standards in public health law was in place, which would transfer this register of interest under your supervision, you would then have the authority to ensure that the law is complied with, when currently there's nothing you can do about it, no more than Joe Blow can say, I was the register complete, because I don't think I have inspected the register, and I don't think this person, their last one on the file is 2 or 3 years old. It needs to be updated. Nothing can be done about it now.
Mr. Chair, I agree with you. It is, and you're quite right, and that's one of the reasons why at the beginning I indicated that the Register of Interest is so important. It is extremely important if we seriously are looking at good governance, integrity, and having the public confidence. Then we need to have the law in place so that the Commission can carry out its duties set out under the law.
Do you have any comment on what appears to be an increase in fraud and other compliance issues in the public service in general over the last couple of years?
I would only be able to comment on my own views, and clearly whether because of the increased vigilance of the Anti-Corruption Commission, the police, and others who are involved in the investigation process, there certainly has been, or seems to be, more an increase in matters being brought to the forefront. Now, whether there's an increase in the commission of such offenses, I think it would be difficult to hazard a guess. But we now have in place, and I believe we can all agree on that, a functioning anti-corruption commission, and investigations are being conducted, and in some instances matters are being brought before the court and they're being dealt with.
However, the chairman of the Anti-Corruption Commission, and evidence of this committee, suggests that he is terribly short-staffed, and just to deal with what he has in hand, he basically needs 100% increase in his number of investigators, because unfortunately he's having to prioritize without investigating what investigations to do. And that doesn't bode well for the state of our anti-corruption. So.
Mr. Chairman, if I may just add to what the difference in the roles are, and the Auditor General did point it out in her report. The role and function of the Anti-Corruption Commission is to investigate and enforce. The primary role of the Commission for Standards in Public Life is to prevent. So we have the tools that we should be using to prevent, but we are not as effective as we need to be.
Mr. Whitaker Miles. Thank you very much for your time. Yeah, go ahead.
Sorry. While I do recognize that the law itself isn't in effect as yet, just as a matter of a standard question I do ask most witnesses, is there anything else that you think that should be included in this law that would make it more effective that was actually omitted? I mean, granted, I know some people are already concerned about the register of interest, but one of the shortcomings I've found with the law itself, and this is just my personal opinion, is that when you're looking at declarations, and I'd raise the issue with the chief officer that was here before, if you see a person appointed to a board that owns a company that's doing, $300,000-$500,000 a year in revenues, then all of a sudden, after their governmental appointment, during the time on the board, their revenues jump up to the millions. I mean, while rather subjective or may just be lucky, but the question is, I mean, those are the kind of things that would naturally jump out when a person starts receiving other contracts that prior to their appointment they wouldn't have gotten. Mm-hmm. I think that is one thing that needs to be clear within the law. And like I said, that's my personal opinion, but in your opinion, is there anything else that you think could be added or should be added to the law that would have made it more effective?
Through you, Mr. Chair, there is one other area of concern that I have, and perhaps at some point in the future, if there's going to be a further amendment, this can be taken on board. But it's as it is now, the law doesn't stipulate what happens when someone retires from office with respect to their declarations. Do their declarations then end at that time, or are they under an obligation to continue declarations for a period of time after they demit office? I know that in some jurisdictions there is provision for reporting, continued reporting for a period of time, 2 years, I believe in one instance, and I think in one instance I came across 5 years. But just to ensure that proper reporting is being done, and when someone demits office, there is not some enrichment that otherwise couldn't be explained.
Thank you very much, Ms. Whitaker Miles. I really appreciate your time here today.
Thank you very much. Thank you, Mr. Chair.
Thank you very much. And the meeting is adjourned. Before we leave, can I ask members if it would be possible to hold an administrative meeting next Tuesday, the 26th at 10 a.m., so we can get some of these reports approved, and I think the Auditor General, you can go, Ms. Rosa, I'm sorry.
That the Cayman Islands is going to be hosting the 5th conference for the Commonwealth Caribbean Association of Integrity, Integrity Commissions and Anti-Corruption Bodies. And it will be in the first week of June, starting from the 3rd through the 7th of June. And we are hoping that we will have many of you in attendance, at least at the opening or dropping in to hear some of the presentations, 3rd to the 7th of June. And we will have quite a number of delegates from around the Caribbean that will be able to share with us their own experiences with laws of this nature. So, thank you very much.
move forward with some of these recommendations flowing from the conference. For those who are delegates